Welcome back to the Thoughtful Realtor. In today's episode, I'm joined by Mark Saakian, probate and trust attorney, real estate attorney, founder of Saakian Law, and Mark also brings a unique perspective with many years as a real estate broker. So, thank you, Mark, for being here today.
Thank you for having me here, Mary.
I'm excited. I'm excited to speak with you because this is such an important issue and area for people that own homes and they don't really know what to do and whether or not they actually need a probate and trust attorney. So, why don't you just start by explaining how's your background as both a real estate broker and attorney shape the way that you approach real estate and real estate law?
Oh, that's a great question, Mary. Well, I was a broker first. I got my broker's license in 2009, and I practiced real estate for many years before I became an attorney. So, from the broker's standpoint, I know what people go through when they are buying or selling a house, the mindset, the emotions, and everything that's attached to buying or selling a home, which ends up being their most of the time ends up being their nest egg, their biggest valuable asset, so to speak. Uh, so from that standpoint, then I went to law school, graduated, passed the bar, and I've been practicing for the past 9 years. And what does that do to you being a broker as well is that it adds an additional layer, so to speak. I start looking at things a little differently. I still have my brokerage knowledge and experience, and now you look at it from a different perspective. It's because law schools, it doesn't really teach you the everything the law, right?
Correct.
That's the, it doesn't teach you everything, but it teaches you how to look at things differently, how to spot possible problems, how to address possible problems that may arise. And when it comes to that and real estate transactions, you start looking at things from the standpoint of where is a client opening up himself or herself to a possible liability, how to protect it, how to curtail it, how to fix it, what needs to be done so that nothing ever comes up and affects their normal way of life. So that's basically it. When you start putting brokerage and law together, it's a wider horizon.
So when you talk about opening yourself up to liability, what exactly do you mean by that? Are you talking
Well,
about having your property move along the path that you intend it to when you pass away? Are you talking about protecting it from lawsuits?
so when you are there are different ways to look at liability, right? But liability in terms of you can address that in terms of buying and selling the property and doing right things that usually brokers do. But if the transaction goes in a direction where, you know, it needs to be addressed in such a way that when a seller sells, it does not come back to them, or the buyer buys and do not encounter problems. But I know your question. The question relates to down the line, what do you do to make sure that the property that you're buying serves its purpose and also serves your family?
Right.
And with that, that's where my estate planning and probate expertise or experience comes into play. It is important to plan around your assets, not only your real estate, but also the rest of your assets, to make sure that uh, it is passed to your heirs in the best and most comprehensive way. And here's what I mean by that. I mean that's probably like a very loaded answer, right? The way you transfer your property to your heirs depends on several factors. Two of the biggest factors are the assets that you have, the types of assets that you have, and the second one is your family composition, your family dynamics. What do you want to do, basically?
Speaking of family dynamics, I'm sure you have encountered a lot of family disruption and dispute and seen people at their most low point at times. How do you handle that?
Well, those situations usually arise when the planning, that's usually, not always, right? they usually arise when there is no appropriate planning done. So if uh, a couple buys a house and then they intend to give it to their uh, children, for instance, but they do not plan that property along with the other assets, and they do not come up with a comprehensive plan while they're alive, when they pass, the children will have to go through probate most of the time to get probate documentation to be able to split everything that they have. And when that splitting time comes, that's when the family splits. Right?
Yes, absolutely. I mean, okay, so just for 1 second, because a lot of people don't really know what is probate as opposed to, there's the probate process and then there's like having a trust. Could you explain that in very simple terms to our audience?
Sure, sure. Um, when somebody passes away, if there are two ways that somebody can address their assets at the time of their passing. You either have something written with your instructions as to what to do with your assets, or you don't. So if you do, it is said that the person died testate. That means that the person had a will. Having a trust goes along with that because a trust usually comes with a will. Those are the set instructions that you have left behind. If somebody dies without a will, it is said that the person died intestate, means without a will, and in that case, not the estate rules that you said come into play, but the state rules.
The state of California's courts.
That's right. And that is where probate comes into play. Probate is a division or a process within state courts that deals with inheritance. This specifically deals with issues related to somebody who has died without a will, how to properly and fairly divide the property, who is going to be administering the estate, and all of the questions, zillions of questions that stem from that. Yeah, probate court also deals with defective trusts, trustee issues, and things like that. Anything that's not related to.
So that's a great answer because I mean, when I speak to clients about this, I tell them, and I don't give legal advice. I always have that disclaimer, but I say if you go through probate, it's going to be more complicated than if you have instructions. And that if you have instructions, you can actually avoid the whole probate process in a state court. So
Let me add something there. Aside from being more complicated, more time consuming, going through a full probate is a year or a couple of year journey, depending on whether your probate gets contested, whether if one of your heirs decides to just throw a wrench into the process, so you have to go through litigation of the probate in order to have it resolved. But
yeah.
other than complications and time, it is also super costly.
Absolutely. And that's why it's so important to plan for these events before they happen. So, I mean, to all the points that you were making, why should homeowners and families consider estate planning before a crisis happens?
Just for that particular reason, to make sure that all of their assets are distributed according to their wishes. And not only their assets, but a proper estate plan does not only address individuals' assets and passing of the assets, but also who is going to be acting on their behalf if they are, for example, incapacitated. So if somebody gets incapacitated and that somebody has, let's say, 3 children, and those 3 children have totally different views or the way that they perceive life and what should be happening.
Oh, families never argue or get into disagreements, right?
Right, of course. But if you designate a person who is going to be making the decisions for you, and you leave specific instructions as to what your wishes are in terms of the medical decisions that need to be made for you, then that plays the crucial role. You are the one running the show, so to speak. And it really avoids or limits conflict within your family. The same is true for a, having access to your assets or to your accounts that are not in a trust, for instance, for your agents via a power of attorney. So if you are incapacitated and you have children who need to access your funds for your care, your maintenance, and they will have no way of doing that unless they go to the court and have somebody specifically appointed to care for those issues. But if you do that ahead of time, then that's called a durable power of attorney that can help your heirs have access to your funds. And that's while you're alive. When that person passes, that's when the will and the trust provisions regarding uh, division of the property kick in.
So, Mark, how do you determine if someone needs a trust as opposed to some other form of estate planning document? I mean, how do you determine what structure is right for a client?
That's a great question. Most of the time, it is the value of the assets that drives that decision. If somebody, I'll give you an example when somebody may not need a trust. For example, a person does not own real property. Their assets are limited to a couple of bank accounts, for instance, some personal property that amount to, for example, $100,000 altogether. If those bank accounts have a beneficiary designation, where the bank will pay those beneficiaries upon the death of the owner of the account, then those accounts do not go through probate. If that person has a will and designates what happens to his or her personal property, that should be sufficient to basically and personal property in this case gets divided within the family without any it can get complicated, but that person will not need a trust.
So I think what you're saying, and my understanding is that if you're depending on the size of your estate that you leave behind, you might not need a trust. And I know recently there's a new law, I think, it's a small state exemption, a small estate exemption for a certain, a smaller size so that more people can bypass the probate process. I think they lowered the amount, that I think it's now around $700,000 where you
Well,
in
it is for a personal it's for the personal residence, primary residence only. And if that person's probate assets, meaning that the person passes away leaving behind only the house that should be a part of the probate, and that house is under $750,000, then it's a simplified petition that they can apply for and have that property transferred into the name of the heirs. But the heirs will need to keep in mind that they will be responsible for any debt that the decedent had.
Interesting. So how is that affecting the number of people that are going through the probate process?
It should lower it, but at the end of the day, I mean, the purpose of that is to limit the full probate cases. So if I do not know the exact statistics, if that's the question that you're asking, but it should be making it easier for people, particularly in California. $750,000 is a good number in my view.
Yeah, I agree. I think it's a high enough number where the majority of homeowners would probably fall into that category. I know in Sacramento we have a higher median home value than across the country, generally speaking. But I think it's going to make it a lot easier for people to handle their residences when they pass without going through a full blown probate process.
Yeah, the heirs will just need to be conscious of the fact that if there are any creditors out there, they may be personally liable for that debt. because they basically sign off on the full probate. With that in mind, some people may still choose to go to a full probate where they notify the creditors, they take care of all of the creditors, and that way, if there are any creditors out there who did not file a claim against the estate, they will never be able to come back and make any homes.
Okay.
So if they know for sure that there are no creditors out there who are going to be coming and knocking on their door, then this is a great process, and it's a simplified process too.
So, Mark, how do you see estate planning evolving as property values and family structures become more complex?
Well, I'm hoping that more people will learn the benefits of having a proper estate plan in place. And in this day and age, with the advancement of all of the technologies and the AI and all that, finding out this information is really not difficult. It's a matter of just sitting down and doing that. I encounter a lot of people who say, spending like two or three, $4,000 on an estate plan is expensive. We can't do that. Okay, well, what is the alternative? The alternative is pushing your heirs to go through probate, where they will be spending 10, 20 times more than that, depending on the size of the estate. And and the probate fees, the statutory fees, statutory meaning the fees that are set by law, that are payable to attorneys and to the executors of the estate, they could be really overwhelming.
I completely agree with you. I have been preaching that for a long, long time. People don't really see the value in spending a little bit of money up front to save a lot of money when they're gone or to save a lot of problems. And it is well worth it to spend a few $1,000s to make sure that your affairs are clearly defined and explained so everyone's on the same page. And, if you don't do that, I've seen cases where the families are at odds with each other. You have to go and find a lawyer. You have to pay for the lawyer. Then you have disputes in the probate court. So I completely agree that prevention is the best medicine.
Yeah, absolutely. Absolutely.
So, Mark, what are the most important factors that people should consider when setting up a trust?
Um, well, as I said, there are two main factors, right? It's the family dynamics and the composition of your family, and the types of assets, and basically your goals. And what will need to be taken into consideration is the value of the estate, where you take everything that you own and add everything up. How much does it amount to? There is a level above which your heirs will have to pay estate taxes. That's a pretty high threshold. It's a high level. At this point, it's 13.9 or $13.99 million per person. So when you're talking about two people, it's like 27, almost $28 billion. So if you own substantially less than that, which is most of my clients, then the goal becomes not the avoidance or protection against estate taxes. By the way, estate taxes are horrendous. It's like 40%. I don't know the specifics.
So just talk.
Yep. And imagine when you're talking about millions of dollars and, that number all of a sudden shows up. Anything over 10%. And some milk. So if that is not a concern, then the concern becomes probate avoidance and passage of your assets to your heirs. There is also an important factor which some people consider. It's uh, avoidance of pursuits by Medicaid to collect, or Medi-Cal to collect from you and your estate in the event if the person ends up in a nursing home for many years. But that's so it gets complicated.
But that's a really important point because I don't think a lot of people are aware that if you are on Medi-Cal, the state and you pass away, the state can come after your heirs to recover the money that they've spent on your if you have significant property, is that correct?
It is, well, yes and no. They cannot come against after your heirs, but they can come after your estate, right? For whatever you owned at the time of your passing, there are many exclusions. Like your primary residence, you do not have to spend everything down to zero to qualify for Medicaid. So if you have some assets and you end up in a nursing home, Medicaid will not pay for this unless you spend everything down to like $2,000. That excludes your primary residence. It excludes a certain amount for your spouse. But it gets too complicated, and I think it's too much beyond this level of discussion. So if that's the situation, if people really want to plan for Medicaid and the event, if they end up in a nursing home for years, they need to start thinking about it now because there's a look back period.
Okay.
Right? It's 3 to 5 years, depending on circumstances. Uh, and so that means that if they end up in a nursing home now, they will go and look back 3 or 5 years to see if you had any assets that you got rid of.
I think that's just such a emphasis on why it's so important to address these issues as soon as you can, because planning is the best preparation.
Yeah, and for just for an average family, the best estate plan and a family that has assets in excess of $200,000, because that is the threshold for simplified estate. And I'm not talking about the 750 where only primary residence is concerned, but simplified probate process. So if any family owns in excess of $200,000, and that qualifies pretty much anybody who owns real estate in Sacramento or in California, right? They should have a plan in place, which includes a trust where a trustee can step in and handle the affairs, or the successor trustee can step in and and handle the affairs in the event if something happens to the trustors. It includes a pour-over will to address any assets that are left outside of a trust to be basically deemed a part of the trust. The power of attorney and an attends healthcare directive. That is the comprehensive estate plan. In addition to that, it is very important for people, let's say with small children, with minors, to think about what happens if an accident happens and both mom and dad are gone.
Yeah, and those are difficult questions
Those
to
are
face, but
exactly,
they need to be faced.
exactly. So if you have minor children and something happens to you, what is going to happen? Who is going to take care of those children?
And that's addressed in the trust.
It will be addressed in trust, and you also can draft appropriate paperwork to designate somebody to basically take care of your kids. Because if you don't, that introduces an additional level of complication within your family, right? Because his brother is going to say, well, I'll take care. And then her sister comes into play. No, no, no. She told me that I can take care of the kids. And the battle begins. Grandparents start jumping in. You go into a probate court. And while those kids are left kind of hanging and waiting to see who is going to take care of them. Really a heartbreaking type of a situation, but it can be avoided with proper planning.
So, what are some of the common legal mistakes that you see homeowners make when transferring property or adding people on title to their property? I see this a lot where people say, "Well, um, I was just going to put my son or daughter on title, since I'm going to leave the property to them anyway."
Those are some of the wrinkles that are associated with proper planning. And those wrinkles are what happens to the cost basis of your property
From a tax
from the
perspective.
tax perspective. Let's say mom and dad bought the house in 1980. 60s for $100,000. The property appreciated to $800,000. The cost basis is probably going to be $100,000, maybe a little more if there were some steps taken, if there were some major remodeling. But let's say $100,000. The value of the property now is $800,000. There are capital gains on which taxes need to be paid if the property is sold.
Right, and so just to differentiate and not to get too complicated, because this is a complicated area, there's capital gains taxes to consider, but there's also a property tax to consider. So right now, you're just speaking to the capital gains issue.
I'm just saying that there are capital gains to be addressed and there are property taxes to be addressed. There are certain exclusions that people can apply for, and that's a parent-to-child exclusion according to Prop 19. Oh yeah, they can apply for, and if they qualify, they can take their parents' cost basis. Basically, the property will not be reassessed when they inherit the property.
For
If
property tax
for
purposes.
property tax purposes, if children inherit parents' property.
Okay, can you just explain in like 2 or 3 sentences what your understanding of Proposition 19 is? Because I use this a lot with clients. It's a great way to save on taxes.
Yeah, Proposition 19 basically allows for a turn up for to avoid a reassessment of property taxes in the event if the property passes via inheritance from parents to children, and in some cases from grandparents to grandchildren. And what does that mean? If a child inherits a property and intends to live in that property and makes that known to the assessor's office that I inherited this property from my mom or dad, I intend to live here. Here is my affidavit to that extent. Then the assessed value of the property will remain the same. So they will continue paying taxes based on what their mom and dad were paying. If that's not the case, if you buy a property, the assessed value goes from whatever the prior owner had it to the fair market value, and the taxes are calculated based on that, let's say, a market value of that land. Right? It's complicated. Try to explain it. I don't know if that did it or
No, no, I think that was great. What I like to use Proposition 19 with older homeowners that,
Mhm.
for example, have held property for a very long time and are thinking of downsizing to smaller properties. They can, if I'm not mistaken, transfer a lot of their tax basis over if they're over 55, and I think there's some other
Yeah,
qualifications.
I think it also applies to veterans and to people with disabilities, but I would just need to brush up my, since I don't deal with that much, it's mostly, you know, most questions relate to the transfer of the property and not uh individuals. Yeah, 55 is over 55 is one of the qualifications for Prop 19. So if they sell this one and buy another one, then they can transfer their uh, uh, assessment based from one property to the other, pay lower taxes.
And I think it's such an important point to make. What you're making is the point you're making is that, there are a lot of complicated factors that need to be considered. And that's why I tell clients you need to have a CPA on your team. You need to have a good estate planning attorney on your team. You definitely need a good realtor on your team. So, all of these things are professional. I mean, you really need a good team of professionals to guide you through this stuff.
Absolutely, absolutely. And if you have any retirement accounts, you need to have a good financial advisor on the team. Uh,
Yeah.
uh,
So should people just add people on title to their house?
I don't think so. Not without proper consultation. I mean, if they consult with the appropriate professionals and they decide to do that anyways, then yeah. But if they just go ahead and do that, it changes things So if you add somebody to a title, you are an individual holder of title, right? You are the only person in title. And you, let's say, add your child and you add them as a joint tenant. That helps in case if the individual owner dies, then the child as a joint owner will not have to go through the complicated probate process. It's a simple process of becoming the owner of the property. But what happens there is that is considered a gift. So you gift a portion of that property to this individual, right? And when this individual who has gifted the property dies, the cost basis does not step up. And we did not talk about the step up in the cost basis, which is it's a large area to be discussed. The best thing would be to really to talk to an attorney or to talk to a CPA, talk to somebody, get some guidance, and get solid replies before doing that, because it can complicate things for your heirs. Maybe not for you, but for your heirs.
And it can make things worse. I think that's the point you're making is if you just do things without knowing what you're doing or without professional advice, it can make life a lot more difficult. Your heirs will get the benefit of a stepped up basis, for example, in certain situations. So,
And that's a fair statement. And also, it can trigger reassessment of the property. So from that point on, you may be paying higher property taxes on the share that was gifted to your child. So your property taxes, if they were a certain amount based on a certain value, will be split into two portions where a part of it is assessed higher and a part of it is assessed lower. And the resulting outcome of that is higher property taxes.
So I just want to ask you also, I want to make sure we touch on this because I do a lot of probate and trust sales. And one of the things I wanted to touch on is I think this is just such a murky area for people when they are going through a probate. They have a loved one that passes, there's a piece of property that they want to sell, and let's say it's in really terrible condition and they have full authority from the probate court. So it's a relatively simple process to sell it. But there's something called a probate referee that will drive by the property most of the time. They don't go in person, and then they assign a value to the property. And if the value is incorrect, let's say it's a lot higher than what the property is actually worth because the property inside is a fixer-upper, that can really affect whether the property is sold in the probate court.
Yes, and that's particularly true if it is a supervised sale. If you're talking about full authority, well, first of all, who's who submits the documentation to the probate referee? It's the executor, or the administrator, or their attorney, right? So when that document is submitted to the referee, it really should be noted to the referee that the property is not in a good shape, and here are the problems. So the referee, when appraising the property, whether it's a drive-by or whether they look at some photos or whatever, they can take that into account.
Absolutely, that's so important. Yes. And I tell clients, I say, I have a listing right now that the property is really it needs a ton of work on the inside. And I told the executor, you need to send photos to the probate referee or information, like you said, just so that they have an accurate assessment of the value.
Yeah, and at the end of the day, if the administrator or the executor has full authority and the heirs do not object to the sale of the property at a certain price, then it could be just fine. It really affects the situation mostly if it's a supervised process where court has to approve the sale.
And that's
With
called
full
limited authority, right?
Yeah, or a supervised sale of the property. But with full authority, there is a notice of proposed action that will need to be sent to all of the heirs. Now, if you're dealing with just a couple of siblings who all have inherited the property and they're okay with selling the property at that level and they both consent to it, then it should be okay. I mean, obviously, I am saying this, but there could be facts affecting this, right? So this is more of a generalized statement. And it's very facts driven, and I have to be intrigued.
Of course. So, Mark, how do professionalism, integrity, and taking a human-centered approach guide your client relationships? Because I feel that's really what you excel at is a human-centered approach with people, besides being extremely capable and an excellent attorney.
Well, thank you. Thank you for acknowledging that. That's it. That is the most important bit, to be honest with you. And that's we are dealing with human beings who are assessing or figuring out what to do with their prized possessions that they have accumulated throughout their lifetime, and their family. That's the other prized possession that they have. The emotions that come into this have to be acknowledged. You really have to understand where they're coming from, and not you have to take into consideration maybe the cultural or ethnic backgrounds of folks who you're speaking with, because it's not just about, okay, here's a cookie cutter. This is, at the end of the day, the papers themselves maybe, but the way to design this, you have to take into consideration the entirety of the situation. For some, cultures, it's a family decision. So maybe you meet with the entire family and you talk with everybody. With others, no, I am the one deciding. I don't care what everybody. So that's the human side of it. And I think it is very, very important to address those aspects of this job.
I
And
like that.
yeah, and that at the end of the day, that's what matters to the clients.
Yeah, and ultimately you're guiding people through a very complicated emotional process. So, I just am so grateful that you came on the show today. And if you're interested in getting a trust or an estate plan or have real estate questions and need a great attorney, go see Mark Saakian. Thank you, Mark.
Thank you, Mary. Thank you for having.
Until next time, thank you for listening to the Thoughtful Realtor in Sacramento, where thoughtful guidance and local expertise support your most important real estate decisions. If you found this episode valuable, please like, subscribe on your favorite platform, whether Apple Podcasts, Spotify, or YouTube, and share it with a friend. I appreciate you being here. Clarity, strategy, thoughtful execution.